Okay, got that. Thank you. Olena Perepalinska, who's a partner and head of international arbitration at the Integrities firm in Ukraine. And we have here today Simon Falwell and Mark Meyer, who will speak as well. So before I pass over the microphone to Dr. Rivas, I just wanted to introduce him. He's the founding partner of Strategy in Washington, D.C., which is located also in Bogota. And he's the chair of their international arbitration practice. He's admitted to practice in District of Columbia, as well as the Republic of Colombia. And he works not only as a counsel in international investment disputes, but also serves as an arbitrator and provides consultation services on public international law, and so forth. As interesting background, Jose Antonio was the former lead negotiator of investment treaties for the Republic of Colombia. He's a former ICSID legal counsel and is currently an adjunct professor at the Georgetown University Law Center, where we teach a course together. And he has his doctorate there and master's in law as well. Just before I pass the microphone, again, I want to thank Lucas. I think he's very modest when he comes and talks about some of his background. Lucas has been a stalwart in the international arbitration field for many years. I know he's now at Kyiv Co, but still affiliated here with the Law School of Queen Mary, and was very instrumental in bringing the School of Arbitration to particular prominence over the past years. And I just wanted to make note of his great contribution to the field, and thank him for helping us organize this today. So I'll ask Jose Antonio to introduce our speakers, and then we'll get on to the panel.
Thank you, Ian, and welcome everyone to this impromptu World Arbitration Update panel. As Ian indicated, this is a topic that we thought to put on in September, but of course, the evolution and dynamism of the events convinced us that it would be better to do it now, and see what has happened in the past six or so months since the invasion from a purely legal perspective. The topic today is yes, the Ukrainian war and the crisis related to the actions of the Russian Federation, but with emphasis on the legal profession, and what lawyers are doing and may do from various perspectives. One, of course, is the ICJ, which Chiara Giorgetti will touch on, the proposal of a commission a la Iran-US Claims Tribunal type of initiative, but also the actions and remedies and execution of assets, etc., that could take place in various foreign jurisdictions, including the UK, the US, etc. So we have really an incredible number of arbitration and litigation international practitioners. But before going into their accolades, I would like to again thank Lucas and Queen's Mary for having us, and do a short introduction of my co-founder Ian Laird. Ian Laird is head of the co-head of the International Arbitration Group at Crowell & Moring. He, as you know, is a professor of international investment arbitration at Georgetown and other faculties of law in the U.S. And he is and was the creator of the Oxford University Press website on investment arbitration, and he has been, in many respects, a huge engine for the World Arbitration Update and also the Washington Arbitration Week and various very interesting academic and education projects on investor-state arbitration and international commercial arbitration. And I want go more in depth into what he has done, but he's an incredible supporter of this type of initiatives. I would like to start by sharing a few accolades about our speakers. Professor Chara Giorgetti is professor of law at Richmond Law School, and she is immediate past chair of ITS Academic Council, vice president of the American branch of International Law Association, and an elected member of the American Law Institute. She is a senior fellow of the Columbia Law School International Claims of Reparations Project and a member of the working group on the development and implementation of international legal mechanism for compensation for damages caused to Ukraine as a result of armed aggression by the Russian Federation. And I could go on and on, but let me tell you a little bit more about our other speakers. Olena Perepelinska is a partner and head of arbitration at Integrities Law Firm. She serves as the president of the Ukrainian Arbitration Association, a member of the ICC International Court of Arbitration, member of the Global Steering Committee of the ERA Pledge, and chairs Arbitration Commission of the ICC, Ukraine, and ADR Committee of Ukrainian National Bar Association. She has acted as counsel, arbitrator, and expert in over 160 arbitrations under a variety of arbitration rules. She's also a fellow of the Charter Institute of Arbitrators, and importantly, she really brings the perspective of an attorney on the ground in Ukraine, which we consider was essential for this panel. Mark Mayer is a partner also at Paula Mooring, but operating from London, and leads its European and Middle East insurance and reinsurance practice. He has almost 30 years of experience advising on insurance and reinsurance claims, and dispute, and has been recognized in the legal industry guides as a leading practitioner in the field of insurance aviation. And one of the key components of Mark being here is sharing with us his knowledge concerning claims as assets that may be seized or not in this time of crisis. Simon Fowell is a partner in the London office of Signature and a specialist disputes firm based in London with offices in Paris and Gibraltar, with more than 20 years of experience across a wide range of commercial and financial litigation and arbitration. He has a particular focus on complex banking and structured finance matters, but also has significant experience across numerous other sectors, including insurance, life sciences, and energy. And especially for today, he has an eye and experience concerning seizure of assets and execution of decisions, judicial decisions, and awards that would be key for our conversation. And last but not least, Jean Bird, who is a Ukrainian-born individual who immigrated to the US at a certain given time, and is a US educated attorney. And I have had the pleasure of working hand in hand with Jean with respect to a particular Ukrainian client that we share. It is particularly interesting to see his perspective with respect to execution of awards in the US, seizure of assets in the US, and what remedies can be used with respect to actions that may take place in the United States. So with that, I will give again the floor to Ian and our first panelist of conversation, Olena, to take it away and delve with the issue of what is being done purely legal perspective by attorneys that that are in the Ukraine, but also have taken the adventure of starting to operate from neighboring countries. Olena, you're welcome to start our conversation.
Thank you very much for introduction, and thank you very much for inviting me to this event and for choosing this topic, which is very important for our country in these times. I would like to start with actually the short description on what is going on the Ukrainian legal market after the launch of the war. Of course, the war has affected legal market in different ways. On a personal level, many Ukrainians decided either to flee or to stay or move within Ukraine. Some decided to serve in the Ukrainian army. And again, this all had a certain impact on their work. But thanks to COVID, we all could work remotely, living in different cities, countries, and that's actually doable, despite all the difficulties we have. Second, on a macroeconomical level, of course, the war has a huge negative impact on Ukrainian business. And this has significantly reduced the workflow from Ukrainian clients. And some Ukrainian law firms and lawyers do have difficult times now because of all these complications. In order to partially solve this issue, many Ukrainian lawyers are now seconded by foreign or international law firms, and this is a great support for the Ukrainian legal business, as this reduces the financial burden for the Ukrainian law firms, gives opportunity to Ukrainian lawyers to gain some experience in international and foreign law firms, and ultimately enrich the entire legal market of Ukraine because of the experience and relations built up during this period. Another example of supporting Ukrainian dispute resolution practitioners is a project of Ukrainian Arbitration Association, which launched an initiative encouraging to appoint Ukrainian arbitrators. And we regularly publish profiles of potential arbitrators under the hashtag appoint Ukrainian arbitrator. But again, there are certain consequences of what is going on in the Ukrainian market. Some partners of Ukrainian law firms decided to move to join some law firms in other jurisdictions. So we have a couple of recent examples of Ukrainian partners joining Polish law firms, for instance, and probably this trend could continue depending on the length of this war and the situation we have. But despite finally, probably I would mention that Ukrainian National Bar Association has opened 5 representative offices in Europe in order to coordinate the humanitarian aid to Ukrainian lawyers and to provide some pro bono services to displaced Ukrainians in respective countries. There are, of course, a number of private initiatives to support Ukrainian lawyers or Ukrainians in different countries. But despite all this, Ukrainian legal community is not just like waiting when this will end up. And we all are trying to make Russia liable for all which is done. It is being done now in Ukraine. And this includes 2 levels of activities, a kind of private level or level of ordinary attorneys and the state level. If we look at the first one, so actually we as Ukrainian attorneys receive on a daily basis requests for Ukrainian business suffering from this war because they either lost their assets or their assets are damaged or they are on occupied territories and they simply don't have any connections or any idea what is going on with their assets. And all of them are interested to recover their damages from the Russian Federation. And there are at least now 3 legal avenues discussed and partially used. I would say first is Ukrainian courts, because recently the Supreme Court of Ukraine passed or formed position, which is quite new for Ukraine, and actually said that Russia should not enjoy jurisdictional immunity in the cases related to the damages incurred by Ukrainian victims of war because of the Russian activities in Ukraine. And this position was further developed in other cases. And recently, our court register has been opened again, and we could see that there is already a number of cases launched by Ukrainian business in Ukrainian courts, and they are looking for recovering damages from Russia in this way. Second avenue is European Court for Human Rights, but this is only for occupied or deoccupied territories. And again, the window of opportunity is closing because the Russian Federation withdrew from the convention and because of other factors. And the last potential existing legal avenue is investment treaty arbitration, again, relevant to occupied territory, but I don't have any information whether anyone has already used it or not. And potentially, and I would only briefly mention that what is discussed now is potential launch of additional legal avenues, for instance, foreign litigation or claim commission, which has been already announced by Ukrainian state officials, including the Ministry of Justice, and already mentioned by our moderators. And actually, claim commission is one of the things done on the state level. It's not a private initiative. And if we look at the state activities, I could only briefly mention that there are different interstate proceedings in different fora, including the European Court of Human Rights, in this case, recently had some developments. There are different ICJ proceedings. There is just recently we see the news about UNCLOS arbitration. So there are certain activities related to different violations committed by the Russian Federation against Ukraine. And like additional field of Ukrainian diplomacy is encouraging foreign countries to amend their national legislation. Ukraine has already amended its own legislation in order to allow confiscation of Russian assets, because ultimately it's not enough to have a judgment, it's necessary to enforce a judgment or a word or whatever, and you need Russian assets for that. So Ukraine adopted its own law, and recently Canada passed new law allowing, in different ways, but actually allowing confiscation of assets. And Ukraine, I know, is trying to encourage other countries either to pass their domestic legislation or international treaty, allowing to a certain extent to do the same and to reach this goal. Here, I would probably stop, and thank you for your attention.
Well, thanks very much, Elena. That was a great introduction to what is a very complex topic with a number of different angles. And you highlighted a few of the issues that I think we're going to ask some of the other folks here on our panel to expand upon. I wanted to ask next Mark Meyer to give us some of his specific insights. Actually, Mark, the camera is only going to get you. Stay seated. Yeah. Mark's background is in insurance, but also related to airlines. And there's been a particular development, of course. There's a lot of airplanes owned in Russia and flown through Russia, as you know. And there's been certain issues concerning the insurance stance around those aircraft and how that impacts the companies that lease the planes and own the planes, and how that all integrates with the various sanctions issues. And we're going to ask Mark to help unpack all of that for us, since he's been dealing directly with many of these issues with his clients over the last many months. So, Mark, I'll hand it over to you.
Well, thank you very much, Ian, and also to Jose Antonio and to Queen Mary for hosting. So I'm not going to take you through everything because we only have a few minutes. I'm just going to give you a gist of what's going on, why, how the issues. I mean, we've heard what's going on to a degree in Ukraine, but this is the effect of what is going on in Ukraine on the rest of the world. And we'll just focus on the aviation and insurance industry for the meantime. So you'll all be aware that sanctions were imposed by various countries after the Russian action. And I mean, US, UK, EU, Swiss, Australia, I could go on. And I'm not going to deal with the sanctions because that's a topic in and of itself. But in terms of aviation, aviation was if you like, a sanctioned industry. And it meant that those entities, anybody in those jurisdictions that I've just mentioned and others, could no longer give support to any part of the Russian aviation industry. And so specifically what that meant was if you leased aircraft to a Russian owner, or a Russian operator, or Russian airline, or somebody with any Russian interest, that was all going to be sanctioned. And the EU and UK regulations gave lessors, the people who owned the aircraft, till the 28th of March. So the sanctions came out on the 3rd of March. They were given till the 28th of March to recover their assets. What also happened was that the maintenance providers, so people who were servicing the aircraft, we call them MROs, maintenance, repair, and overhaul. Those entities also had to withdraw their services. So that was going on sanctions. So what did the lessors do? I mean, you've got all of these planes, and there were hundreds, truly about 500 aircraft. So what did they have to do? So they started giving notice under their leases to say, right, well, we want our planes back. Now, one of the issues will be, well, what does the lease actually entitle you to do? I've seen many leases in my time, many aircraft leases in my time. I've never seen one which has a sanctions clause, which says, oh, if we get sanctions imposed, you can then got to give us back our aircraft. But there are other provisions, and we'll come to them as to whether or not the lessors can actually use those provisions. But what they did do is where those aircraft were either overflying or were located in friendly countries. So, for example, Russian operators had flown some of them to Turkey. In Turkey, the lessors were able to get orders requisitioning those aircraft back, i.e. so stopping them being thrown out. And about 100 or so aircraft were recovered in that way, either through overflights, and so they were jurisdictions that said, right, you divert, and they made them land, or they were actually on the ground. So I think you may be able to see some slides. I am just going to. Yeah, okay, we can go 2 more. We're up to what do the insurers do. Behind every aviation entity is insurance because almost every country that I know about has a law that says you can't fly aircraft unless you've got insurance to cover your liabilities for the actual aircraft hull, the hull itself, and liability to passengers and liability for people on the ground in case for property and people. So the insurers gave 7 days notice of cancellation. So let me just explain to you what that entails. All aviation policies allow insurers to cancel in certain respects. One of those is war. For the outbreak of war, they can tell you cannot fly out the plane we're insuring to a war zone. And that's exactly what they did in this case. So they actually said, we are withdrawing all types of insurance cover for anything involving Russia or Belarus. So if you're flying there, overflying, you're situated there, whatever it is, zero insurance. And we have to, under the terms of the policy, give you 7 days notice. Insurers started doing that in the week of the invasion. So that was 24th of February. By the following week, pretty much everybody, all of the market. And I should just explain that the aviation insurance market is largely headquartered in London. The Lloyd's insurance market and the companies market. I mean, they're not the only places. There are other insurers in other parts of the world, but a large chunk of that market for all types of aviation, no matter where that risk is located, is led in the London insurance market. So we've got the situation that by the 2nd week of March, that notice would have been given. And and will kick in 7 days later, so roughly mid-March. Okay, what did the Russian Duma do? So what did the Russian Parliament do in response? So they, and I'm again just focusing on the aviation aspect. So what they said was, we will allow foreign registered aircraft to be registered on our register. Why was that controversial? It was controversial because the Chicago Convention, which was 1944, so it goes back quite a few years, one of the leading aviation conventions. For those who couldn't hear, one of the leading aviation conventions. What that said is you can only, at any one time, you can only register an aircraft in one jurisdiction. So with the Russians saying, no, Russia is a signatory to the Chicago Convention. So with the Russians saying you can now register the aircraft on our register too, technically, that could be a breach of the obligations under Chicago, depending on what the other country's registration requirements are. In some cases, where your airworthiness certificate is withdrawn, and that's what happens, right? I should have said the lessors, to try and stop these aircraft being flown by Russian operators, actually cancelled the airworthiness certificate. So it meant that those planes were no longer certified by their owners as being airworthy. And therefore, if you don't do that, actually your insurance is invalid and your registration is invalid. And they thought, well, that will be the end of it. They won't fly these planes. So Russia's response was, okay, well, you can put it on our register. So the issue then becomes, is that a breach of Chicago or not? Because in many jurisdictions, there is a process to remove an aircraft's registration. You can't just say, all right, I've now registered. Now you've actually got to follow it. You want to deregister. And that didn't happen. And what the Russians also did was to say, we will not allow you to pay installments on your leases, and you cannot return your aircraft without Russian approval. Of course, won't surprise you to hear that really no approvals have been given. So, so that led to insurance claims being filed. And let me just explain to you how aviation insurance works. There's essentially three, I'm going to call buckets, where you get insurance. The largest, the most significant is what's called the all risks policy. And here I'm talking about operators rather than manufacturers. Because it's not the component manufacturers or the airframe manufacturers. I'm talking about operators of aircraft, airlines, commercial operators. The all risks covers, as its name suggests, all risks, except war and allied perils. So to the extent that you see a war, and so the loss of an aircraft is due to war, or due to a deliberate malicious act. So the example would have been the German wings, remember the German wings crash, where it was a deliberate action of the pilot. That is treated, the hull loss, not the passenger liability, but the hull loss is treated as a war loss and is dealt with by a different set of insurance to the all risks. So the all risks is everything that isn't excluded. And essentially what isn't excluded is picked up in the, what is excluded is picked up in the war and allied risks. But backing that, so that's with the airlines. Backing that is something called contingent insurance, again, split between all risks and war. And what that does is to say, right, for aircraft lessors, you should be additional insured under the primary policies of the airlines operating your aircraft. So you should have insurance already, but to the extent you don't, we will give you, so it's contingent on you not under those policies. So the contingent backs up these core policies. Generally speaking, then the highest policy limits are with the all risks. The insurers have denied liabilities, and now there are claims in various jurisdictions. Simon actually mentioned to me the filing yesterday. It wasn't filed yesterday, it was filed last week, but reported yesterday a claim by AirCap, which is the largest aviation lessor. It is seeking $3.5 billion in terms of its, it says its losses to Russian aircraft. It has almost 200, certainly into the hundreds of aircraft, they say, with Russian lessors, Russian operators, and they cannot get that back. So they filed a $3.5 billion claim in the UK High Court. That is against the all risk insurers. And there is a second claim, an alternative against the war and peril insurers, saying, well, if we can't get it under the all risks because it's treated as war, we want to get it under the under your policies, and that has limits of 1.2 billion. The issue for insurers is not just that underlying claim. All of those insurers will have reinsurance. So it's an insurance of that original exposure. That's called reinsurance. And those reinsurers will have different attachment points, but there are different considerations in terms of what they pick up and not. These are, although intended to be back-to-back, some of the original definitions will be interpreted differently depending on the operative law of those agreements. So my last slide, I think we're going to end very shortly, but I just wanted to take you through some of the issues that we see in that case. Firstly, the characterization of the Russian action. Of course, we know that it's not been described as a war in Russia, but if you look at the dictionary definition, it pretty much looks like a war to me. Lease provisions, well, we mentioned those. Do they actually permit termination of the leases? And one of the issues is where the registrations have been happening in Russia. At least in two of the cases I know, the registrations have been in the name of the original owner, so in the name of the lessor. So that creates another issue as to whether or not there's actually been a misappropriation. They're not registering it in the airline's name, the operator's name, they're actually registering it on the Russian register in the name of the original owner. The date of cancellation, we mentioned the insurances got cancelled. But at what stage, at what event, what stage were those assets, if you like, I'll say, taken over or sequestrated by either the operator or the Russian state? Remember that the sanctions didn't kick in. The first day the sanctions apply is 29th of March. Many of those policies, almost all of those policies, will have cancelled by that stage. So you've got a date of an event as to what was the event that gave rise to loss and what was the insurance in place at the time. So, and then there's the scope of the insurance. Insurance, most of the all risk policy, for example, will have a war and allied risk exclusion. And that covers invasion, stealing of assets, all of that sort of thing. So the true definition of what, or the true scope of those insurances is going to be up for loss, and then calculating the loss. I mean, are these planes gone forever? Will they be returned at some stage? Any asset sitting on the ground doing nothing, particularly a plane, is a deteriorating asset and will take a lot to put back into service, particularly where there are no maintenance records, where whatever maintenance is being done is not being done by approved operators because none of the Russian MRO facilities are any longer approved. So they're not going to be approved in the jurisdiction where these planes will become registered again in the EU, UK, US. So calculating loss is an issue, and then recoveries. To what extent, when aircraft are recovered, or where there is a claim against the Russian state, as may well happen, and there are avenues to do that, to what extent can those be taken into consideration to offset them? So that gives you a flavor. I may have gone slightly over, so I apologize for that, but I'm happy to answer questions at the end of their presentation.
Well, thanks very much, Mark, and I'll ask Jose Antonio to introduce Simon.
Well, thank you, Ian, and thank you, Mark, for giving us way more than a flavor about the insurance world and especially with respect to the things that may be now in control of Russian Federation and affected by them. Simon, I'll introduce Simon, and part of the question with respect to the crisis created by the Russian invasion in Ukraine deals with what else can be done outside of course, Russia, and in a jurisdiction that has, from what I understand, a significant amount of assets that may be owned by Russians or by contacts with the Russian Federation or some of its state-owned enterprises, etc. And this is a field which Simon knows quite a bit about, and we're welcoming his remarks on the issues.
Thanks, Jose Antonio. So there's been an awful lot of talk about potential claims against Russia as a sovereign state, particularly through bilateral investment treaty claims, or potentially against Russian companies, be they state companies or private companies. And why you may be able to get a judgment against these entities, obviously that's precious little good unless you can enforce against the judgment that you have and get some sort of compensation for your loss, which takes us into what you do want to do. Now, you'll be pleased going to try to take on a whistle-stop tour through every aspect of enforcement. I don't think 5 minutes is going to touch the surface on that. But what I am going to do is point out one or two things which are potentially relevant, particularly where England is concerned as a potential jurisdiction for enforcement. As Jose Antonio rightly said, that there are a lot of Russian operations with assets within this jurisdiction, and so people tend to look towards England as a potential destination for enforcement at an early stage. So, first thing to say, I think, is that generally speaking, England is considered a pretty friendly jurisdiction when it comes to it. Now, that's partly because there are good processes in place for recognising foreign arbitration awards and also foreign court judgments. But also, once you have your judgment or award recognised, there's a pretty decent toolkit when it comes to how you then go about accessing the assets that you're after. So, it's the usual array of charging orders, injunctive relief to freeze assets if they're not already frozen, and also some fairly substantial rights to obtain information about where assets might be housed. Now, if we look at arbitration awards momentarily, they're enforced under the New York Convention. Most countries now are parties to the New York Convention, and it's a pretty straightforward process to go through. There are limited defences that can be raised to enforcement, in particular where it breaches the policy of the company to sort. But there are also certain technical defences, including where there hasn't been due process allowed to the party against whom enforcement is sought. Now, some of that will come into play in the current situation, and we'll start to go into that. Because I think two of the issues you're looking at in terms of Russia and Ukraine are, firstly, what do you do where the party you're looking to enforce against is a sanctioned entity? And secondly, what do you do when you're looking to enforce against a sovereign state? Because there are challenges. So, looking at an entry-level point, particularly when it comes to arbitration and this point of due process and the ability to represent yourself and put your arguments across. The exclusion is on the basis that the party against whom the award is invoked was unable to present its case. And it's important to look at the word unable. It conceivably gets called into question where there's a sanctioned entity that's struggling to find legal representation as a result. I think, though, it's pretty clear now that it's going to be a struggle for a party to claim that they have been unable to present their case because they've struggled to find what they consider to be adequate legal representation on the basis of sanctions. To give an example, it's now pretty clear from a very recent ruling a couple of months ago from the Privy Council, it was an appeal from a payment ruling, that the correct law to be applied to the question of whether the party has been able to put its case is a matter of the law of the jurisdiction in which enforcement is sought. So, for example, if you're looking to enforce in England, you're looking at English law, but the standard to be applied is an international law. So it's not just a case of looking at what might be considered due process in England. You have to look at what due process would be that can be applied to any arbitration in any state. So the decision also highlighted, first, the pro-enforcement object and purpose of the New York Convention. The whole purpose of the convention is to aid enforcement, and so the limitation should be construed pretty restrictively. And they also focused on that word unable that I mentioned at the outset. And they said that that sets a very high bar before you can rely on the loophole to get out of enforcement. So if you look at that, I think from a sanctions perspective, on the whole, most of the sanctions provide for some sort of license to be available where a party is to seek legal advice and legal representation in an arbitration. So where there's a license, you may not be able to instruct your first choice of law firm. And of course, there's been an awful lot in the press about law firms being reluctant in some instances to work for certain particular entities. That in and of itself is unlikely to be sufficient. Similarly, I think there's also the possibility that a party could put its legal arguments itself without necessarily having legal representation at all. So again, it's going to be difficult to rely on that. However, notwithstanding all of the parties to arbitration have been pretty conservative where they've been faced with a sanctions entity that's struggling to find legal representation. Generally speaking, you want to have a represented party on the other side to ensure that due process is served and to avoid any potential problems down the line. So actually, you will often see arbitrations at the moment being stayed until one of the parties that's been struggling has managed to find legal representation again. And also where that's not been possible or where it's taken too long, you're sometimes seeing the claimant party effectively putting both sides of the case in an effort to make sure that justice is served and the arguments are put on behalf of the defendant. So it's something to keep firmly in mind. When we're looking at enforcing against sanctioned assets, in principle, it should be possible to enforce a judgment against a sanctioned entity or against sanctioned assets, but it will depend on the terms of the sanction itself. Quite often, you'll need a license in order to be able to enforce. Whether that's going to be granted, well, that's going to depend in large part on what you're looking to enforce, what the reasons for the enforcement are, what the sanction actually says, and what the terms of the potential licenses may be. And again, you can see there's been some debate in the context of sanctions against Syria here in cases already through the English courts. But there is a debate there as to what the sanctions genuinely aimed at. You know, is it really aimed at preventing a party from depriving the other side of assets, the sanctioned entity of assets? Arguably not. But equally, some of those sanctions are aimed at stopping business. And there is an argument to say that by granting those licenses on a very regular basis, actually you're not really you're not really preventing that business in the longer term. So, interesting issues on the sanctioned entities. Sovereigns, again, generally speaking, enforcement against sovereigns is not particularly straightforward. Russia, well known for the fact that it doesn't often voluntarily pay investment treaty arbitration awards against it, and the assets it has to enforce against overseas tend to be limited. Certainly from an English perspective, you can enforce against sovereign assets where they are used or intended for a commercial purpose, and equally there tends to be a line drawn between the state and state-owned companies, unless those companies are an organ of the state. Now that obviously cuts both ways. You know, if you're up against a Russian entity, for example, it may be considered a sovereign, but not an organ of the state, then there shouldn't be a sovereign immunity problem to enforcement. But equally, you can't generally go at the state-owned vehicles as a means of getting enforcement against the state itself. So again, it can be quite challenging when you're looking at investment treaty enforcement in particular, but there are means. I think on that note, you know, to go much further takes us very deep into the topic, and it's probably not just a session on its own, but probably an entire suite of sessions. So on that note, I'll pass on.
Thank you very much, Simon. And without further ado, I will give the floor to Jean which will share with us his perspective on a very, very similar topic, but from the U.S. perspective. And as I said, I've had the pleasure of working with Gene on a case that involves enforcement of an award for a Ukrainian party, and this is somehow very, very similar. But I will let Gene share with us the specifics of ins and outs of asset tracing and looking into the various ways of enforcing awards in the U.S.
Thank you, Jay. Appreciate your invitation to this panel. To you and Ian as well. It's a great panel, and it's an honor to speak together with distinguished speakers here. And my very brief presentation, I want to be very brief and perhaps leave more room for and time for questions. But my topic dovetails, as Jay correctly noted, with what Simon was talking about. And the general question is can be summarized by a phrase from one of my favorite movies, The Big Lebowski, is where the money. The end result is that's basically the end result of these claims. Of course, putting aside any criminal court actions that ICC actions against Russia, which would eventually will take place, or some type of international tribunal to punish those who are responsible for atrocities committed in Ukraine. Of course, the big question is the compensation to businesses, compensation to victims of the Russian aggression. And if you go through arbitration, through any international arbitrations, if you go through any Ukrainian court actions, you will eventually need to enforce your judgment and execute and find the assets. And as Simon correctly noted, Russia is not famous for paying its debts, legal debts, the judgments and arbitration awards voluntarily. There are only a handful of cases going back to the 90s where Russia was forced to pay. And there is of course, we know we're very, very all familiar with the UCAS case, where the arbitration award of $50 billion, one of the biggest awards in history, was issued, and the UCAS shareholders are still after Russia and trying to collect on the assets. So where's the money? That's the question. Of course, there are assets. There are assets that belong to Russia, to the Russian state, and there are assets that belong to the Russian state-owned companies. These are, of course, the legitimate targets for any asset recovery, and many of these assets are right now under sanctions. And similarly to what Simon was describing the situation in the UK, in the United States, these assets are under sanctions as well. So just a brief explanation what sanctions mean, because I think there are many people sometimes they have misunderstanding of what sanctions are. Sanctions is not a confiscation of assets. Sanctions basically when the United, at least from a United States perspective, when the United States imposes sanctions against an individual or company or foreign state, it does not mean that the United States confiscates these assets. All it does, it just makes these assets untouchable. Nobody under jurisdiction of the United States of America, whether it's a U.S. person, a company, or a person located in the United States, has the right to touch this asset, to deal, to make transactions with the assets that belong to the sanctions persons. That's the bottom line. So the assets are still there, they're still available, but they cannot be touched. So how do we deal with that? There is a agency in the United States, part of the Department of the Treasury, called OFAC, Office of Foreign Asset Control, that deals with sanctions and that issues licenses. And before before you can enforce, you can attach any assets that are presently in the United States under sanctions, you do need to obtain a license. And I believe Ian would tell more, provide more details about that. How do you deal with OFAC and other and the related issues? But it's just a little clarification. So the assets are still there. You still need to have a court order to attach these assets. You need order to execute against these assets. How do we do that? In the United States, there is the law called the Foreign Sovereign Immunities Act that provides jurisdiction to federal courts in all actions involving foreign states. In the general premises, the general percept of this law is that the foreign states are immune from actions in the United States, except certain specific exemptions. And these exemptions are the commercial activity exemption, expropriation exemption, arbitration exemption, waiver, and there is one additional, there is also the torts in the United States exemptions, but probably less relevant to what we're talking about today, but and the terrorist exemption, which is a separate exemption that was that the law was adopted in the United States to provide the victims of terrorism with assets that were that are located in the United States. All of these exemptions could potentially be used to bring an action in the United States, and this action could be the action on the merits to sue a foreign state in the United States. B, it could be an action to enforce arbitration award, a foreign arbitration award or international arbitration award in the United States. And C, to enforce a foreign judgment in the United States or execute against a foreign state. Most often we see actions to enforce arbitration awards. Why? Because there is a specific exemption in the Foreign Sovereign Immunities Act for actions to enforce arbitration awards against the United States, which is a later an exemption that was adopted later on after the adoption of the FSIA itself, but it's very specific. And the courts are very familiar with this exemption, and there are many judgments issued by the United States district courts, federal district courts, against foreign states based on the exemption, based on the arbitration exemption. Once you have, you need to have a judgment in the first place before you can actually get an attachment of foreign property of the foreign property of the state of the property of a foreign state in the United States. But having a judgment is not enough. There are few other steps that you need to overcome. There are the law, the Foreign Sovereign Immunities Act, is protective of foreign states, regardless of what conduct was the basis of the basis of the judgment. And the law provides the special additional protections to foreign state. There are the plaintiff or the claimant in the court needs to obtain special orders to allow attachment and execution before the attachment and execution can be permitted. Also, once you have a judgment in the United States, and typically it would be in the district court, in the United States District Court, which is a federal court, this judgment is technically effective only in one district. So you do need to have a special order from the district court in order to be able to enforce this judgment against assets of the foreign states that are located in other districts. The next, there are a few other points that I'd like to also emphasize. One is that in addition to the immunities that I mentioned before, these are all what they call jurisdictional immunities. They govern whether a suit can be brought in the United States courts and where it can be brought in the United States courts. The next set of immunities are execution, immunities against execution. They're separate immunities. They're similar to jurisdictional immunities, but in addition, they generally impose one additional requirement as far as execution attachment of the property concern is, and that requirement is that the property that is subject to attachment and execution must be used in commercial activity. So that sort of creates an additional hurdle in terms of what assets can be used to what assets can be used can be attached in the United States. That said, courts might, depending on the case, but the courts, of course, they do have discretion. There are certain case law on what can be what is considered to be commercial activity with respect to the attachment of assets. But there is for example, case Chabad versus Russian Federation, and that's a very interesting case in terms of the what type of actions were considered to be commercial activity in the United States. And in that case, the lending of books from the library, from the Russian State Library, to the United States, to the libraries, to the Library of Congress, was considered to be a commercial activity. So the courts do have discretion. So even the minimum level of commercial activity could be a commercial activity that would involve exemption under the Foreign Sovereign Immunity Act. 30 seconds, wanted to mention discovery in the United States. United States has a very broad discovery. So if you get a judgment, you get to do a discovery in the United States, and it's not typically, discovery is not limited by foreign sovereign immunity. Moreover, there is a possibility to involve what we call Section 1782, that's 28 USC 1782, that could be used to discover relevant information for use in foreign proceedings. So even if you have proceedings in Ukraine, in the UK, or other countries, you can invoke 28 USC 1782 to obtain a relevant discovery in the United States. That's all I got. Thank you.
Well, thanks very much, Gene. That I think we should probably do a whole panel on related discussions on sanctions and types of impacts. Just a final point before we finish off with Professor Giorgetti. You alluded to the FSIA, the Foreign Sovereign Immunity Act. And I think one of the big issues that has been floating around is whether the U.S. will designate Russia as a state sponsor of terrorism. And this is a critical designation because it would create all sorts of additional unilateral sanctions. But to your point, it would remove sovereign and diplomatic immunity under the FSIA with the terrorism exception, which would allow terrorism victims and their families to file lawsuits in the United States. And that's an absolutely critical potential path. And I know President Zelensky has asked the United States to make that designation. I don't think it's happened yet, but that could be a real development when that happens. So, everyone be watching out for that. And so let's go on to kind of a broader international kind of viewpoint. And we're very honored here to have Professor Chair Giorgetti from Richmond Law School near Washington, D.C. and in the state of Virginia. And very happy to have you here. And Professor Giorgetti.
Many thanks. It is really an honor to be here today, and a pleasure indeed. I see that we are running a little late, so I'm in your hands in as far as my speaking time, and if I need to abbreviate or anything, just let me know. But as others have mentioned, there have been a lot of very interesting initiatives that are now being thought and also being taken to think about how to react to Russia's aggression and injuries that have occurred. Because really there is no doubt that Russia's aggression in Ukraine violates international law, and as such, as an act of aggression, through the articles on state responsibility, Russia has an obligation under international law to pay reparation. And so the question is how to obtain these reparations. Other speakers before me have mentioned some. And I think what I would like to do today is really thinking about claims commission, which is one of the issues that we are exploring in the international Committee on Reparations and Damages that the Columbia Law School has created, and as requested by President Zelensky to look at this issue of reparation. So look at the issue of claims commission. First of all, we have several examples that exist that provide a very helpful blueprint, and I'd like to mention some very briefly so that we can build on that then to look at the possibility for Ukraine. So first of all, look at the United Nations Compensation Commission. This was created by a resolution of the Security Council to look at injuries that were generated by Iraq's aggression and occupation of Kuwait. This was a very long process. The commissioners that looked at these injuries were many and acted for many years, with priority for compensation on very specific amounts to individuals that had to flee Kuwait. This was, again, a Security Council initiative. A follow-up, not a follow-up, but a commission that was created after that, a very different one, the Eritrea-Ethiopia Claims Commission. This was built as a bilateral agreement, and this looked very much like an arbitration panel, so that there were five arbitrators, commissioners that look at damages, including damages for violation of humanitarian law and of law in bello and law ad bellum. The different kind of solutions also, but also look mostly at claims by states from Ethiopia to and Eritrea. And then another predecessor to the UNCC. And of course, the UNCC also looked at claims from different states in the region that suffer injuries. But the Iran-US Claims Tribunal, the Iran Claims Tribunal was maybe the first one post-World War II that looked at compensation using a claims commission kind of framework, looking at injuries that were suffered by Americans, by US nationals, but also US companies because of acts in Iran, but also Iranians and the Iranian state. Were compensated by and are still compensated by the US. So a very complicated, very different kind of claims commissions, each one successful in their different sphere. And I think what that shows is that really claims commissions can be very flexible. They can be constructed in different ways. They can act in different ways in terms of duration, in terms of composition, and of course in terms of jurisdiction. So how does this help in looking at the claims commissions for Ukraine, which is very much something that I think is very, very feasible. So what would be the goal to create a claims commission for Ukraine? That would be to create a legitimate and very clear process that is rooted in international law, which is able to provide and disburse funds because and to compensate injuries caused by international law violations by Russia through binding awards. I was very pleased to hear Simon and Jean talking about the where the money is, right? Because of course this is very important and one of the main questions here. But what are some other questions? What are some other questions here that we are thinking about? And of course, there are issues of, so what are the claimants? Who should be compensated? Here are, of course, all those individuals that suffer because of Russia's aggression in Ukraine, that had to flee their residences. They had to, sometimes they are internally displaced, but many had to flee Ukraine altogether. How do we compensate those individuals? How do we compensate the state also of Ukraine for all the destructions that was caused, all the loss of infrastructures and cultural property? So on one side, who are to be compensated and on what ground? Here I said that Russia, of course, had committed an act of aggression, but it's also violating other international law provisions, including humanitarian law, including human rights law, and many provisions also related to international economic law, investment law, and possibly environmental law. So what kind of claims is an important question. Who would be the claimants? And then, of course, two other issues. One is, what is the mechanism, how to build a claim commission? Some examples that I mentioned were bilateral treaties or Security Council resolutions. Here, those options do not exist. Of course, Russia, as a P5, has veto power in the Security Council, so the Security Council is not really a venue that is open. But is the General Assembly a venue that is open, that can be built, where something can be built, or maybe an international law process, an international legal process that includes not only, it's not a bilateral treaty, but is more of a multilateral treaty. And then, of course, what are the individuals, what kind of violations, what kind of claims, the mechanisms, and of course the compensation, where is the money from? And I was really glad to hear Jean and Simon talking about this, because in addition to all the frozen funds, we also have the funds from the Ukrainian, the Russian State Bank, and many other funds that are possibly available, looking, of course, also at all the issues of immunities that arise. I think I overstayed in my time already, but if I have one more minute, I just would like to say that in addition to this, the compensation, the claims, the claim commissions, mechanism that we are looking at, there are also many other international legal mechanisms that have been addressed. So I've heard many is already in domestic courts, but of course we also have the case at the International Court of Justice, which is a case that Ukraine brought against Russia on allegation of the genocide under the Genocide Convention. Here, the International Court of Justice already issued an order on 16 March 2022. And here it's very interesting because Ukraine essentially said that there was no commission of genocide that would allow any Russians act in Ukraine. And the ICJ ordered Russia to refrain from any military activities in Ukraine pending the resolution of all the cases, and of course as initial violations of international law. Some have mentioned already the International Criminal Court. There's a very interesting proceeding that are occurring there too. Of course, the European Court of Human Rights process, but also the Commission of Inquiry that was created within the Human Rights Council, also by the United Nations. And finally, also in thinking about it, similarly to what we were thinking about ad hoc processes, the possible creation of an ad hoc tribunal for the crime of aggression. So I think what it really shows is there are many different actions that are being undertaken within courts and tribunals that already exist, but also possibly looking at ad hoc processes that might be interesting and feasible under the circumstances. Thank you, and I'm very happy to see if you have questions.
Thank you very much, Professor Chara. There's one general question that I would like to put on the floor before we go to our public, both virtually and in person. I would like to invite each one of our panelists to think within the framework of those actions that are being led by legal professionals, whether in terms of efficacy within your field, the actions that are being put forward and being made by counsel makes sense in terms of creating a deterrent, either immediate or in the short run or in the long run, against what Russia is doing. So, for instance, in the case of the insurance and reinsurance industry, would insurance or reinsurance claims might create a sufficient financial incentive or deterrent to see a change of mind. Equally, for instance, in the jurisdiction of the United Kingdom, might there be sufficient assets so as to create an incentive in the short or medium or long run for changing the behavior, and so on and so forth. And of course, in the case of the ICJ, there comes a question as to, well, the ICJ has ordered this, but at the same time, the Russian Federation would initially not accept its jurisdiction. So why does it make sense that the claim is submitted, and why those efforts might make sense even though immediately there might be no change of minds, and the question may be extrapolated to each one of you. So if you could take just no more than 3 minutes to answer, I would welcome our first speaker, Mark.
Okay, so, well, certainly from the insurance and reinsurance perspective, what is happening now is making Russia very pleased to think that, well, why should we pay? Because insurers are going to pay. But there is already a discussion. It had started with COVID, where whether insurance and reinsurance by implication or by extension should be used for systemic, these types of systemic loss. So where you have a global pandemic, where you have a global action, should it really be the case that that's what insurance is there to address? And the short answer is it requires policy changes, the changes to the wordings of what insurers are willing to pick up. But that's a debate with the brokers. The brokers are selling these things, and so in the short term, no, I don't think it's going to hurt Russia. In the long term, yes, it will, because those Russian entities will also find it very hard to find insurers for their those operators, and there's going to be less willingness to give them things. But then when people realize that insurance won't be an answer in the future, that could create some type of
I mean, I suppose I come at things from a slightly different angle in that I don't see the work that I do in terms of working for my clients trying to seek compensation or enforce contractual rights as aimed at the Russian state particularly, or trying to change behavior. It's simply a collateral impact of what's happening in that situation. The situation does give rise to sanctions. It does give rise to contractual issues. It will create tensions in the finance markets. And to be frank, some of these disputes that we're seeing don't have any particular Russian nexus at all in terms of the parties concerned. There's a claim running through the English courts at the moment where you're looking at a trade for the transfer of bonds issued by a Russian bank. And the question there is, firstly, whether sanctions prevent that trade from happening. And secondly, if that's the case, then how should the parties' losses be apportioned? party trying to sell on some bonds. It's contracted with another non-Russian party. It happens to be a broker. That broker was working for the Russian bank seeking to buy back its own bonds. You can see there that the question is whether the buck stops with the broker in the middle, whether the buck stops with the party that's trying to sell its bonds in the first place, who's looking to enforce its contract. None of that will have any impact whatsoever, particularly on the Russian state and how it operates in the future. But it is absolutely an issue that needs dealing with, and it needs dealing with effectively through the court or arbitration process.
Thank you, Simon. And now, Jean.
Yeah, I think the way I see, I agree with Professor Giorgetti, is that there is a strong necessity for an international effort for a combined international effort to deal with this type of issues. To me, if I look, I'm not a historian, but it seems to me that there was a conflict of that scale since World War II took place, particularly in Europe. And even if you look outside of Europe, there hardly was any conflict of that scale of destruction, of that scale of human suffering, of this scale of damages. So just to use conventional legal mechanisms that exist right now might not be sufficient. You need something more, and certainly a type of a commission, a compensation commission, that would provide the platform to review the cases, to review the claims, to review the damages, and find ways to obtain funds to compensate the damages would probably be a very important, certainly a very important step in what President Zelensky is doing right now, and what Professor Giorgetti and her group is doing right now to developing a framework for such a commission would be very important. Does not mean that the existing mechanisms should be forgotten. They should be used. Does not mean that for national mechanism, for example, type of laws that existed in the United States, like, for example, Helms-Burton Act, that provided a way to compensate victims of a Cuban expropriations. But it has to be a combined effort. And that's the point that I'd like to carry over.
Thank you, Jean, and Olena, and
Thank you. I would start probably with saying that from Ukrainian perspective, there is a huge demand from Ukrainian society to make Russia liable, to make Russia pay these damages. And even though the existing legal avenues are not perfect and even uncertain in all the aspects in terms of enforcement, they still make decision to pursue some of them, because ultimately they hope that one way or another, Ukraine, together with international community, would find a way to tackle with this blatant violation of international law, actually, which bears the risks for the architecture of existing system of international law and international order. And of course, we need, as Jen just said, we need to join efforts in order to solve this situation. Indeed, it's something new and unprecedented for this system, for this legal order. And we do not have any tools ready to do that. We need to create them using some historic examples, probably. But again, our situation is different, because all of the examples included some consent of the respondent state for any proceedings, collections, etc., etc. This is not the case now, and we have Russia in the Security Council of UN, and this is another problem, actually blocking some other legal avenues we could have had. So that is, we really need to find a way, we really need to join efforts and to do that. Thank you.
Thank you, Lena, and of course, Chiara.
Thank you very much. Just to build on what my colleagues have said. Of course, here I'd like to kind of mention two things. One is, yes, as Alina just said, this is Russia, and it's a very different situation because Russia has veto power in the Security Council, which means the Security Council is not really a venue. Not that the Security Council has always been a venue before, right? Has been blocked before. But I think what is different here and now are several things. One is that the international community, and especially in Europe, but not only, has reacted quite strongly to Russia's actions. So the European Union, but also the Council of Europe, and many others have been quite straightforward in saying, this is not acceptable, and we have to find a way to deal with it. At the same time, the international community also has been quite straightforward, and I'd like to mention some actions at the United Nations level. So, for example, the use of the Uniting for Peace resolution of the General Assembly, which allows for the General Assembly to take over when the Security Council cannot fulfill its mandate to look at security issues of peace and security, or the maintenance of peace and security. Then, as a secondary organ, principal organ of the United Nations, the General Assembly can, using this Uniting for Peace resolution. And this is exactly what the General Assembly did. Looking at and then with the resolution very explicitly saying that Russia had committed an act of aggression in Ukraine, and this was an overwhelmingly accepted resolution with very few, only 5 voting against, and few abstentions. And this, I think, is very important. And at the same time, not only concerning Russia, but concerning the impossibility sometimes of working in the Security Council, Resolution 76/262 of 26 April 22, which essentially gives a standing mandate to the General Assembly to debate any issue that was vetoed in the Security Council. So I think there are some movement, some realization that the Security Council is not the perfect system, and maybe the General Assembly can possibly do more. And so I think that we have several mechanisms that are now being used on the specific situation, Russia and Ukraine, and possibly that will also led to a systemic change in international law. So I like to say that this might be a turning point, and that might be something that we will see as something that has changed how things are being done in international law. And of course, what is not, with clear, one has to go with clear eyes. Is not all simple. It's not all easy. But I think we see some positive movements.
Thank you very much, Chiara, and everyone. I would only like to say that I fully agree that this seems to be a turning point, not only because it's Russia, but also from the public international law perspective. Given that aggression, of course, can not only be committed by Russia, but by any other sovereign state. I would like to give the floor to our kind attendees here in person in case there's any question. And if you have a question, you're more than welcome to approach the table and share your thoughts here for any of the speakers, or hopefully all, but not all. Any questions here? Yes, would you like to come and sure. Yes, and share your
Hi, I have a question for Chiara. My question is related to the exhaustion of remedies. So there are so many different venues where Ukrainian individuals and companies can pursue compensation. For example, what if they get an ECHR judgment or a local court judgment? Would that be a problem then for a future claims commission?
Thank you. This is a very interesting question. I think if an international mechanism comes to fruition and is adopted, of course, it has to take into consideration that, and as the ICC and other instruments already consider, I would think that it should give priority to international decisions over domestic decisions. But this is something that certainly will have to be explicitly be considered and adopted in an international instrument. I don't know if did I reply to your question? Is that you're asking?
Yeah, more or less, yes, thank you.
Thank you. Any other question? Yes.
Well,
Speak loud.
I have an open question to the panel, and my question is, to what extent do you consider international arbitration as an effective means of receiving compensation for damages incurred while the conflict is still ongoing? And be that as it could be first-hand damages in Ukraine, or it could be indirect damages, for example, as breach of contract for delivery of gas to many European countries. So to the extent that the conflict is still ongoing, is that an effective means of seeking compensation, or put differently, under what conditions would this become an effective way of seeking compensation?
I mean, to take that first, I think it all goes back to the important points at the other end. That you need to say, for example, you're bringing a breach of contract claim. You need to know that there are going to be valid means of enforcement once you've got your judgment. Clearly, you're able to bring an arbitration. That's what the clause provides for, and you can get recourse through that arbitration tribunal. But if there aren't assets then to enforce against, if, for example, it's entirely the entity is entirely within the Russian state, then you may be better waiting for a period, keeping in mind limitation, obviously. Where you're talking about entities with assets outside of that jurisdiction and assets in London, for example, then yes, absolutely.
I would just answer that. So you've got exactly that situation with these aircraft, because the loss hasn't crystallized completely. It's a continuing developing loss situation. It will get worse and worse. But I think the way that those owners of those aircraft see it was, we want to establish the liability side first, and we'll do that right away. And then we'll seek judgment after judgment. We'll top up on judgments, as it were, as we can prove greater and greater loss. So I think that's the way, in terms of assets located there, that I'm seeing it work.
So there might be like a bifurcation to it, started by
Absolutely.
Now, and
Absolutely.
quantum until after the conflict is resolved.
Yeah, or there'll be an interim award. I think that's probably, or an interim judgment, with the opportunity to, liberty to fly again. So I think that's exactly what will happen with bifurcation, but also I think preliminary issues, because certain points will have to be decided because they will dispose of the case, and then we get to the next stage. And that's how I see it.
Just if I may add, I believe Simon alluded to that, but arbitration, the most important to remember about arbitration, that arbitration is a creature of assent. You cannot have arbitration without some type of agreement, some type of contract that provides for arbitration. And in that context, most of the arbitration that we see against foreign states are based on the bilateral investment treaties or multilateral investment treaties. Even there are several recent arbitrations against the Russian federations that arose out of the Russian annexation of Crimea. Going back to 2014. Now these arbitrations, some of these arbitrations are now in the U.S. courts at the recognition stage and execution stage. But again, you do need to have some type of international treaty, like Elena mentioned before about the treaty of the sea, the arbitrations with respect to the capture of Ukrainian vessels by Russia, and that there are some certain treaties that address this type of situations. But in arbitration is great because as far as U.S. law concerned, you do have very concrete exceptions from sovereign immunity, but at the same time, it's limited in terms of what type of situation it can apply to.
Thank you.
Well, thanks very much. I think we're going to wrap it up there. We've extended our time by a few minutes, and it's a real pleasure to have such a fantastic group of people give us the benefit of their experience on this ongoing crisis, and one that may not be resolved soon, but certainly the legal community has been watching developments very closely. And I think one thing coming out of this discussion, and I think part of the ongoing discussion and debate, is that there are remedies, there are alternatives that the legal community can provide. They may not be fast, they may not ultimately be effective, but there are a wide range of activities that can occur to try to seek some form of justice. And this may be the opportunity, as Professor Giorgetti has discussed, to actually do some new things, to actually try to intervene in this crisis in a way that's never been done before. And from that point of view, I guess we'll wait and see, and we'll be talking again, I imagine, soon about this topic. So just a final note, wanted to thank the World Arbitration Update organizers, Jose Antonio, Maria Lucia, and Anna Milena, for all their hard work in organizing this session. And again, welcome folks to attend the update at the end of September. And so, and Jose Antonio?
Okay. Thank you, Ian. And in addition to thanking Queen's Mary and Professor Mistelis and our wonderful audience here with their questions, and also those 60 plus that were and are still connected virtually, I would like to share with you that we will be trying to share some of the sources and readings that our panelists have shared with us in preparation of this, so that we can put that in the website of World Arbitration Update. I mean, I know that we have just touched or brushed the tip of the iceberg, and people would like to know more about the various means that you can seek assets to make a difference concerning the war in Ukraine and against Ukraine. And so that will be up. The video of this session will also be up. And finally, my colleagues in World Arbitration Update will share the screen very fast as to the sessions that we will be having from September 26th to 30 on World Arbitration Update. We will be having proceedings of about 20 to 22 panels that will be airing from the Americas on the first day, from Africa on the second day, Africa and MENA on the second day, from Asia on the third day, on Wednesday, from Europe on Thursday, and lastly, various topics, more international ones that may be airing on an Eastern Standard Time schedule. So most of these panels will be virtual, but we will have in-person panels. In the case of the UK and Europe, we will be airing from Paris, France. So you're more than invited to go to the City of Light if you wish, or join us virtually. With that, again, we're really grateful to all of our panelists, and hopefully you had an interesting experience. Thank you very much, and we'll see you in September.
Thank you. Bye-bye.
Bye.
Bye-bye.